All right, so I think we're ready to go now, and so I'm going to spend today thinking about the most recent Supreme Court decision, perhaps one of the most consequential Supreme Court decisions. It's hard to pick your poison, but of the last several years, the so-called CASA case, Donald Trump versus and
Mhm.
a CASA is a counsel appointed for the special assistance of someone who cannot represent themselves, in this case, a newly born baby who was being excluded from birthright citizenship under Donald Trump's executive order number 23. And in the case in question, the judge didn't just rule that it was unconstitutional given the plain language of the 14th Amendment to deny a person born in the United States citizenship of the United States. The judge issued a nationwide injunction preventing the executive order not only from going into effect in the case in question, but in any other jurisdiction in the United States. And the Supreme Court did not rule yesterday on the constitutionality of the executive order. And I think it's frankly a little disturbing that they didn't rule on that, though the way they construed the case, it was not necessary for them to rule on it. But the idea that for the time being, the Supreme Court has no opinion on whether or not the 14th Amendment actually means what it says it means is a little revealing and disconcerting. What they did rule on was the legality of nationwide injunctions. And their holding, quite simply, was that judges can't do this. And we've discussed this before. We discussed this at the time there were oral arguments in this case. And I thought I had detected on the court some agreement between the three liberal members, Justice Roberts, Justice Amy Coney Barrett, maybe even Neil Gorsuch. And in the end, what I heard in the oral arguments is not reflected in the decision, as opposed to trying to devise a standard that eliminates the abuse of nationwide injunctions while indicating the conditions under which they are permissible. The Supreme Court totally invalidated the practice as I understand the decision. I'm still coming up to speed like many of us. It's a long and complex decision. But the holding in the case clearly is that now Donald Trump's executive action depriving children born in the United States whose parents fit certain criteria of birthright citizenship is going to go into effect in 26 states where there hasn't been a lawsuit. And similarly, we'll see a large number of the judicial decisions constraining the Trump administration are not overturned, but they're narrowly limited in their scope to the particular case or the particular jurisdiction in which the decision has been reached. This is a big win for Donald Trump. I think he's absolutely right about that. I think it is also a big loss for our constitutional system of government and for the structure, the architecture, the relationship between the branches of government and within the federal judiciary that sustains and maintains the rule of law. And so I'm going to start with an analogy. And I'm a little hesitant to use it given who the Secretary of Health and Human Services is these days. But we know that antibiotics are abused, right? That they are over prescribed and that there are adverse health consequences to their over prescription, in particular, that some bugs develop immunity to antibiotics when antibiotics are used when they don't need to be used, is a genuine problem. Does that mean we should stop using antibiotics? And I think, right, putting it that way, the answer is obvious. No, we don't want to eliminate an incredibly valuable remedy simply because it is misused sometimes. And exactly the same thing I think is true with national injunctions. They are misused sometimes. There is venue shopping. They do introduce incoherence at points into our jurisprudence. And it would be beneficial for the Supreme Court to guide us in figuring out when they can and should be used and when they should not be used, because to use them in those circumstances would be abuse. But having said that, that is not what the Supreme Court did yesterday. The Supreme Court, as opposed to that, totally eliminated the capacity of the ordinary circuit level judge or the appellate judge to issue holdings that apply beyond their immediate jurisdiction, even in cases where the basis for their holding is one that obviously applies beyond their jurisdiction. And the consequence of this is that it will be much more difficult for many people to assert their rights, to have their rights protected. It will be much more difficult for the judiciary as a whole, the federal bench specifically, to serve as a check on the abuse of executive power, on illegal or unconstitutional exercises of of presidential power. And the result, frankly, is that today, every person in this country is more vulnerable to having their rights violated than they were yesterday, right? And so I think it's worthwhile concentrating on this topic. I'll note with a little bit of irony internal to my own lectures, it was almost exactly a year ago that I gave you a lecture that the title of which was that our institutions will not save us from our politics, or cannot save us from our politics. And I'm returning to that title. Our institutions and our Constitution will not and cannot save us from our politics in 2025. And by the way, the inverse of this is also true. Only our politics can save our institutions and our Constitution. Trump has been unleashed by the Supreme Court in this term as he was in the previous term, when the Supreme Court held that the President of the United States cannot be prosecuted after he leaves office for criminal things he did while in office. There is an expansive view of the presidency that is at stake here, and it is coinciding with a president who has an incredibly expansive view of his power, and a president who wants to use that power to fundamentally change the fabric of American life, the direction of American politics. And by the way, it's not an accident that the majority of the Supreme Court shares a lot of Trump's substantive policy agenda and is not getting in his way, even when his use of executive power appears on its face to be clearly illegal or unconstitutional. So I have familiar images on the board, right? A US senator being led out of a federal building in handcuffs before being pushed to the ground, roughed up, right? The troops on the streets of an American city in order to intimidate dissenters and protesters. And then, of course, the various images of the decay and degradation of the Supreme Court, and with it, the Constitution. This is, it seems to me, really a significant day in American politics and really worth drilling down on. So to start with, right, on the one hand, we have the term, right? Now almost entirely in the rearview mirror, the 2024-2025 Supreme Court term. And I don't know whether there will be a ruling still on the race and congressional redistricting case that I think everybody expected would be decided yesterday. But I just want you to see the pattern, right? And so there are actually a fair number of 9-0 decisions in the major cases. That is, decisions in which the three liberal judges, the three justices appointed by Democrats, saw eye to eye with the six conservative justices, the justices appointed by Republicans. And then there are a few cases where things break in a different way, but those cases where the court did not find ready unanimity were mainly decided 6-3, and all of the major 6-3 cases, it is the six conservative justices voting as a block, the three liberal justices voting as a block. And so those of us like me who hoped that maybe we could count to five with John Roberts and Amy Coney Barrett breaking ranks with the conservatives are sorely disappointed in this Supreme Court term. The Supreme Court is behaving much more like a partisan institution, like the judicial wing of the Republican Party. This is bad for its legitimacy. This is also bad as far as I think I'm concerned, but many other people who are not necessarily fully partisan Democrats are concerned for the Constitution of the United States, especially during Trump's second term, when he is fully implementing the autocrat's playbook. The courts were our last bastion of defense. The courts are ultimately governed by the Supreme Court. The Supreme Court appears to be highly reticent to check Donald Trump. And so to give you a sense of why this matters so much, look at this from Adam Bonica of Stanford University diagram, right? That in the federal district cases, right, and there are about 250 cases where Donald Trump's executive actions are being challenged in court. And I would point out that that reflects the fact that the Trump administration is in its second coming, its second iteration, increasingly willing to use executive action in ways that not only apparently exceed the usual authority of the president, but also directly countervail or contradict the standing law, right? And we've talked about this together before, whereas another president might try to get Congress to change the law, the Trump administration is simply saying, we don't respect that law. Maybe we don't think that law is constitutional, and therefore we're going to violate it via executive action. So when it gets to the federal district courts, Trump is losing 94% of the time in the roughly 90 cases that have been decided so far. When it gets to the circuit court, he's doing a little bit better. He is losing only roughly 70% of the time and winning roughly 30% of the time. But obviously, that is still a major setback, a very high ratio of defeat. When his cases get to the Supreme Court, he is prevailing 93% of the time. And so please note that the rate of loss in the federal district courts and the rate of victory in the Supreme Court is almost exactly inverted. And we'll get more into this. There's this idea of a shadow circuit, right? That the Supreme Court can issue emergency orders or stays. And when it does so, it does not issue an opinion, right? And a significant portion of the administration's victories have been on the shadow docket, right? This is important, right? Because in a sense, it doesn't allow the people who object to these decisions to even understand the basis on which they were reached, because there is no opinion, there is no hearing, there are no arguments, right? And the increasing reliance of the Supreme Court in the shadow docket has been, I think, rightly subject to scrutiny from a lot of the critics of the contemporary court. But please note the most recent case, Trump versus CASA, in a sense makes it still more difficult for the district courts or the circuit courts to provide relief. It makes it such that the Supreme Court does not have to intervene to overturn those decisions or to stay them via the dark circuit. Very quickly, just to get a sense, right? And we've talked about this together before, right? That the cases that Donald Trump is losing, that the Trump administration is losing, there's a roughly similar ratio of loss in front of Republican appointed judges and Democratic appointed judges. And so I don't think it is right to say that this is all just the Democratic appointed judges using their judicial power to resist the president of the United States. It seems more credible to say this is the president of the United States avoiding the law and federal judges doing their job in upholding the law. But we should also note, right, that the growing skepticism of federal courts to the president's claims seem to reflect the fact, on the one hand, that the judiciary is increasingly skeptical that the Trump administration is a good faith actor in court, right, and in its respect for the law and for the courts, that this is leading them to not have the deference to the executive that it might normally have, because they don't believe that the executive is actually trying to follow the law or trying to make good faith arguments in court, so much as looking for legal pretext to do what it wants to do. And that, right, whether it's tariffs or deportations, the federalization of the National Guard, Harvard law firms, the Department of Education, right, all of these areas, the courts have restrained what Trump is trying to do. Some of those decisions have been overturned on appeal, but it is now increasingly clear that there's a collision course between the courts and Trump, that Trump is increasingly targeting the legitimacy of the courts. And this then is the context, I think, in which the Supreme Court, one way to put it, is blinked in its game of chicken with the president yesterday, right? Got out of the way of a president who was coming after the federal judiciary, questioning its legitimacy. And so when we look at what the recent Supreme Court decision does to these cases, right? Again, relying on Adam Bonika's very good work, the idea that of the 82 cases that district court judges decided against the Trump administration, right, those that are likely nullified by the CASA decision, right, it's roughly 82. I'm sorry, I've got that wrong. No, 82 no, 50 of the 82 are affected by CASA, right? In the circuit court, 17 of, right, I'm sorry, again, 8 of the 17 cases are affected. And so this is a profoundly impactful decision. Many of us have been treating the courts as the last bastion of defense against an autocratic and increasingly authoritarian presidential administration. And the Supreme Court essentially said yesterday that it does not want to join the fight on the side of the Constitution against a president who wants to, in the view of many of us, abuse the power vested in his office in order to accomplish his agenda in ways that he can't accomplish through ordinary legislation. So let's now turn to the opinions themselves. I'm going to start with Sotomayor's dissent in this case, and we'll get to just how heated the language is. I'm calling this a partitioned court. There really is, at this point, two fundamentally incompatible understandings of the Constitution at work in many of these cases. And the result is that we are witnessing a kind of constitutional crisis play out in the Supreme Court that mirrors the constitutional crisis playing out in the broader society. We no longer have a consensus on the meaning of the Constitution, even a thin consensus on its core meaning, on central issues like what powers the courts have, what powers the president has. And I think this is just absolutely clear in what Sotomayor, also what Ketanji Brown Jackson say in their dissents. Starting with Sotomayor, the court's decision is nothing less than an open invitation for the government to bypass the Constitution. Please note, right, the right conjunction of the court and inviting the government to bypass the Constitution. The court's primary role, historically and constitutionally, is to preserve the Constitution, the rights it enumerates and entrenches, and the structures that it dictates from transient majorities and administrations that want to abuse their power. And now, as opposed to doing that, Sotomayor is suggesting the court is inviting the government to bypass the Constitution. The court is abdicating on its fundamental role, in other words. The executive branch can now enforce policies that flout settled law and violate countless individuals' constitutional rights, and the federal courts will be hamstrung to stop its actions fully. With the stroke of a pen, the president has made a solemn mockery of our Constitution. Rather than stand firm, the court gives way. The court abdicates its vital role, right? Again, the directness, the strength of the language, and I think, frankly, the soundness of the analysis that the Supreme Court is not doing what the Supreme Court was designed and intended to do, and is in essence saying we will not do that going forward, is stunning. And then there's this exchange, right? Justice Amy Coney Barrett wrote the majority decision. Justice Jackson wrote one of the dissents, and Barrett replies directly to Jackson's dissent. Here is what Jackson says. And again, the sharpness of the language, I think, is stunning. The very institution our founding charter the very institution our founding charter charges with the duty to ensure universal adherence to the law now requires judges to shrug and turn their backs to intermittent lawlessness, right? So the Supreme Court is preventing the lower courts from enforcing the Constitution, from playing their constitutional role. Jackson signs her decision with deep disillusionment. I dissent. And remember, the custom, the long-standing custom here is to say, I respectfully dissent. With respect, I dissent respectfully, because these are, right, 9 people who have to continue working together, have to continue sharing chambers together. It's important for them to maintain collegial and respectful relationships despite their profound disagreement on issues of constitutional law. Jackson seems to be saying in this dissent, it's not the first time in recent years that there is a disagreement that is beyond the capacity of collegial respect to cushion, right? That she can no longer see her brethren in the court as deserving respect seems to be the implication of the way she signs her dissent. Note Justice Barrett's retort. We will not dwell on Justice Jackson's argument, which is at odds with more than 2 centuries worth of precedent, not to mention the Constitution itself. I'll get into a little bit of that in a moment, but note this. We observe only this. Justice Jackson decries an imperial executive while embracing an imperial judiciary. And I do think that there is some insight in what Amy Coney Barrett is saying there, which is to say, when you have a president that is hell-bent on using executive power in ways that are illegal, unconstitutional, to maximal effect when they cannot effectively legislate, you need a judiciary that checks and thwarts the president at every turn. And we know that Stephen Miller, right, our favorite criminal in the Trump administration, the arch villain, I guess I should say, right, has accused the judiciary of judicial tyranny, right? And there is a sense in which this is, I think, an accurate diagnosis, right? The way in which Harvey Wilkinson, in his majority decision, I think it was a unanimous decision actually, in the Abrego Garcia appeal, put this. Now the branches come too close to grinding irrevocably against one another in a conflict that promises to diminish both. This is a losing proposition all around. And I think there are at least two different ways to read the Supreme Court decision yesterday. And it may be that different factions within the majority were persuaded by one or the other. One way to read this is as a kind of institutional pragmatism. The Supreme Court does not have the power, does not have the popularity, the legitimacy, the authority, the institutional resources to go head to head against the executive for 4 years. That is a losing proposition. The judiciary is going to lose, so we have to get out of the way. I think the other way to read this is that the judiciary, actually, the Supreme Court, the majority of the Supreme Court, I have to be careful, agrees with much of what Donald Trump is doing and is therefore trying to fashion a decision that allows Donald Trump to do it. That they do have an expansive view of executive power, and so long as the executive is using it in the way that they agree with, they are happy to license the president to do it. It will be an interesting case to see. Imagine, I'm not sure it will come to pass, but that the Democrats win the presidency in 2028, that the Democrat who wins the presidency basically says the lesson to draw from the Trump presidency is that the president can do more or less what he or she wants with executive power. And therefore, I'm going to start doing what Donald Trump did, just imposing my will on the executive branch, and that includes things that violate the law. Will the Supreme Court, if it still has the same conservative majority, say what's good for the goose is good for the gander? We will see how political this decision was at that point. I'm now going to read you Adam Bonica's longer analysis of this case, because I think it's extremely important to recognize that this case does not just allow Donald Trump to continue to do much of what he's doing, make it much more difficult for ordinary people to have the protection of the law or the Constitution if they don't have the resources to bring a suit in their own jurisdiction or to join a class of people in a class action case, which is a difficult thing to do, right? How is the class constituted? Is everybody in the class really affected in the way alleged? There's more complexity and difficulty in bringing class action suits. It also, in addition to that, in addition to making it more difficult for people to assert their rights and have their rights protected by the judiciary, it changes the balance of power within the judiciary. It gives the Supreme Court a lot more power by dramatically scaling back the power of circuit judges and appellate courts. And in so doing, by the way, it also implicitly gives much more power to the other two branches, and especially to the president. So let's read this. I know it's a long passage, but I think it's worthwhile because I think the analysis is very good. The majority's reasoning that courts should not exceed their own power even when the executive has is a hollow justification for a radical shift in the balance of power. This reasoning, however, masks a far more significant practical outcome. An executive policy can now be deemed likely unconstitutional by a court, yet continue to be enforced against millions of citizens who were not party to that specific lawsuit. This shifts the burden onto challengers to organize complex, time-consuming class action lawsuits to achieve the same broad relief that a single injunction once provided, giving the executive a crucial advantage in both time and resources. And please note something for a moment, right? The executive already had crucial advantages, right? The President of the United States has the entire Department of Justice and a whole bunch of other executive agencies working for him. The people who are being targeted, for instance, by the executive action number 23, eliminating birthright citizenship, very often are the poorest and most vulnerable people in our society. The judges who were issuing these nationwide injunctions were trying to level the playing field. This decision prevents them from doing that. This move is simultaneously the culmination and escalation of a strategy I previously outlined. For years, the court has used its shadow docket to lift injunctions against the Trump administration, but that was a piecemeal effort. The one advantage the lower courts retained was their capacity. They could hear and rule on far more cases than the Supreme Court could ever review. In recent months, this bought precious time to defend the constitutional order. That advantage has now been annihilated. In one fell swoop, the court has engaged in a judicial blitzkrieg, effectively nullifying or narrowing dozens of injunctions without having to hear the merits of a single case. Because the court lacks the capacity to grant a full hearing to all these challenges, the checks placed on the executive are now functionally eliminated. And so we like to say that our Constitution institutionalizes a system of checks and balances, but it doesn't do it by itself. It does it based on the understanding of the relative powers, scope for action, and the mutual respect of the different branches of government. The Supreme Court fundamentally removed a whole range of checks and balances yesterday. And again, it's so striking that the institution charged with doing this is the one that is abdicating on its responsibility to do so. So, what does this mean? It means the Supreme Court of the United States is abetting the Trump administration's frontal assault on the 14th Amendment, on civil rights, on the rule of law, and a whole bunch of regulations as well. So the executive order in question here is in contradiction, at odds with the plain language of the 14th Amendment on birthright citizenship, right? All persons born or naturalized in the United States and subject to the jurisdiction of its laws are citizens of those states and the United States, right? That is what the plain language of the 14th Amendment says, but now in 26 states, persons born in the United States will not have their citizenship acknowledged by the federal government, right? And I just want to note very quickly, it is due process under the law. It is the equal protection of the law. It is everything in the 14th Amendment that the Trump administration is going after. And it is stunning that the Supreme Court, rather than standing up for the plain language of the Constitution, is abetting the administration in violating it. Trump is also reversing 60 years of civil rights enforcement in the federal government, again, with a few strokes of his pen. And not all of this has been challenged in court, and maybe not all of it will or can be challenged in court. But again, I think it helps us to understand how now all three branches of the federal government are working in concert to reverse the advances in civil rights made in the last 60 years. Nicole Hannah-Jones has, I think, a very good article coming out in tomorrow's New York Times on this. I highly recommend it to you. I'm going to distill just a few points. The Office of Federal Contract Compliance Programs, right, which basically says you can't do discriminatory hiring if you have a contract with the government, their mandate and staffing has been revoked. The standard of disparate impact liability, which basically says you don't have to demonstrate overt racism because most legislatures and individuals and corporations who are engaged in discriminatory practices are smart enough not to say out loud that we're discriminating, but nevertheless do things very often that have discriminatory impact. So judge the effect of the legislation, of the action, not simply the intent. That's what the disparate impact liability standard does. And note that it is now been revoked by the president, right? Reorienting the Department of Justice Civil Rights Division to focus more on discrimination against white people, doing the same thing with the Equal Employment Opportunity Commission. There is a idea here, right? The concerted attack on diversity, equity, inclusion is part and parcel of this broader effort to dismantle the civil rights enforcement apparatus in the federal government. The theory underlying it is that white Americans have been systematically disadvantaged by civil rights. Now, if you tried to make that argument in a court of law, you would immediately run into a substantial problem. There's basically no evidence to support it. There is a broad-based feeling structure out there. I think it's absolutely right. There's research by Pew and Gallup and others that shows that probably a majority of white people feel that they have been disadvantaged by civil rights legislation and civil rights policy enforcement. The truth is, of course, that white people still exceed black people in wealth by a ratio of something like 10 to 1. That the cases of discrimination in hiring, in admissions, in other aspects of the administration of the law, like criminal justice, are clearly, decisively against black people and people of color and other so-called suspect groups, and not against the white majority. So if you had to argue this in court, well, you would have to provide evidence that is lacking. But if you can do this unilaterally via executive action and not have it challenged in court, then you may very well be able to prevail. I think that is, unfortunately, the era we have just entered. The effort to restore a traditional Christian morality as it is perceived by people within the Trump administration and people on the Supreme Court via law and executive action, because frankly, the majority of the people in the United States will no longer voluntarily, spontaneously, organically produce traditional Christian morality and govern their conduct accordingly. So you have to impose it on them using state action. This is part and parcel of the attack on, quote, woke ideology. And it's occurring not only at the level of the federal government, but it's also being brought to bear by the federal government on the states and on civil society institutions. This is the campaign against the universities. Please note, right, that the president of the University of Virginia resigned yesterday once it became clear that the Trump administration would withhold federal funds for the university because they didn't like him, because he wasn't on board with their anti-woke campaign to a sufficient degree. And so I would just point out, right, that this is an effort in essence to use the federal government to reimpose a morality that has lost traction with the majority of the American people. I do think, especially at the level of the Supreme Court, especially with people like Clarence Thomas and other very conservative members of the court, there is a sense that what happened in the 1950s and 1960s is that the Supreme Court represented a minority perspective, that they imposed their minority values on the rest of the country via judicial decisions, and that slowly but surely the country changed as a result, and that the current Supreme Court, in essence, hopes to do the same thing in reverse. Restore traditional Christian morality, scale back the value of privacy and autonomy and individual decision-making case by case. And it now sees itself, the majority of the Supreme Court sees itself as having an ally in the Trump administration, and perhaps an ally that is going to do this with greater power and speed than they can do it on their own. I'd also note an oligarchic subtext to the CASA holding. Only those with the resources to bring suits can potentially avail themselves of judicial relief. This is a problem throughout the judiciary. It is not the case that the equal rights, the equal entitlements, the equal protection under the law is equally available to all Americans, because many of us simply don't have the resources or the courage to sue, right? And so, right, illegal, unconstitutional executive actions will be enforced against those who don't have those resources or are unfortunate in terms of the jurisdiction they reside in. Finally, I'm going to say that the Supreme Court is increasingly embracing Nixon's view of executive power. And if you remember on the Nixon tapes, Richard Nixon is caught saying, if the president does it, it isn't illegal, right? And so the idea that the president is essentially above the law, or the president through his action makes the law, and the idea, right, this is very much at stake in the Trump v. the United States case, US versus Trump case, in which Trump is given immunity from criminal prosecution, and so too are future presidents, and now it's at stake very much in the CASA case as well, right? This will have profound implications for civil rights law, for due process and equal protection under the law, but also for the anti-regulatory and environmental agendas of Trump and the Supreme Court of the United States. It's going to strongly limit the capacity of circuit and appellate courts not only to push back on the violation of civil rights, but also on the abuse of power in the violation of regulations. So again, the context in which this occurs is one in which Donald Trump as, right, Michael Lutig puts it, had planned since day one to go to war with the judiciary. And we see this, right, in what Carolyn Leavitt says, right, that the judges are using their judicial power to usurp the authority of the President of the United States from carrying out the mandate that the American people gave him. Now, I just want you to remember, right, that almost 50% of the American people voted against Donald Trump, and more than 50% of the American people disapprove of the way in which he's presiding as president, right? And so the idea that our system of checks and balances is meant to protect the plurality of views in our society, to give those who lost the most recent election certain rights and protections, and to demand that they too have a say in how power is exercised in the United States. The fact that the Supreme Court is acting in a way that does not respect the internal pluralism of the people of the United States, does not reflect our moral and religious diversity, appears to be increasingly partisan and polarized, right? In which, as we can see, the Republican appointees are voting together as an ideological bloc. The Democratic appointees are voting together as an ideological bloc more of the time than they have at any moment in the last 70, 80 years. That we get more and more concurring opinions, right? This means even the majority is not holding together, is leading to a sharp disapproval of the court and a partisan breakdown of opinion on the court. And then I think we have to remember, right, that in many ways, the Supreme Court is an institution of amplified minority power, right? In that 6-person majority, 5 of the 6 were appointed by presidents who did not win the majority vote. Many of them were confirmed by votes in the Senate that represent a bare majority, or in fact only a minority of the American people, the senators who voted for them, right? And so the idea that the Supreme Court should be cautious in the way it exercises power, should recognize, well, maybe there's a conservative majority on the Supreme Court, but that doesn't reflect the idea that there's a stable majority of the American people that agrees with their conservative interpretation of the Supreme Court, of the Constitution. And please note, right, of course, the Constitution is an exercise of popular sovereignty. It is made in the name of we the people of the United States, right? Not in the name of the majority of the justices of the Supreme Court. So I will be very brief about this. I'm deeply worried that we have the most conservative Supreme Court majority that we've had in a very long time, and that it is using its power in a supremacist and a reckless way, that it is doing so in ways, we've talked about this together before, I'm going to kind of push through this rather quickly, that potentially amplify the power of the minority in American electoral politics. The Supreme Court increasingly is not, it appears, a forum of principle where constitutional issues are discussed on their merits, but the judicial wing of the Republican Party. They are doing things that benefit the Republican Party in terms of benefiting the Republican president, but also in terms of the way in which, right, money influences politics, right? The fact that the Supreme Court invalidated Citizens United and has continued to rule in a similar way in subsequent cases to let more and more money into our politics as our society has become more and more unequal and oligarchic, that they are allowing for gerrymandering, that they are dismantling the Voting Rights Act and other civil rights protections. All of this suggests that the Supreme Court is, in essence, doing things that dismantle the basis for equal power of those who oppose its current majority. It's doing things that make unions much less powerful as well. And that let me stop with the slides now and open it up for discussion. But I just want to point out, I think there has been a hope on the part of those who do not agree with this administration, that we had a last bastion of defense, at least for our constitutional rights and maybe for some of our other legal protections in the courts, and that the courts seem to be rising to that challenge. What the Supreme Court did yesterday is going to make it much more difficult for us to rely on the courts. It's going to make it much more difficult for those of us who want to restrain what we see as the abuse of rights and the abuse of power of this administration to do so by writing checks to the ACLU or like-minded political and legal organizations. That I think it is at this point crystal clear. If we're going to try to restore and protect the rule of law against an autocratic president, well, we need to look to leaders like Gavin Newsom, who are increasingly aggressive in just directly taking the fight to President Trump, suing Fox News, etc. But even more importantly, we are going to have to encourage each other and our fellow citizens to organize, to protest, right? To remember, right? There was a period prior to the Civil Rights Revolution that got us the Civil Rights Revolution. It was the era of the civil rights social movements. And by the way, that's a much more difficult kind of politics than using the courts to sue. But it appears that it is now increasingly the case that we can't rely on the courts. We're going to have to take our politics to the streets. We're going to have to make our resistance, our dissent manifest, and disrupt politics as usual, business as usual, in order to protest against a federal government that is increasingly moving in a direction that I believe the majority of Americans oppose. I'll stop there. Want to hear your thoughts. I'm sure you must have them. Who wants to start us out today? David, go ahead.
There's one thing I don't quite understand here, and maybe you can help me do it. The In the particular case, 22 states brought this suit to the district court, or I guess it was the circuit court, and an injunction was issued. And now we have the Supreme Court ruling that says that this can't apply uniformly across the United States, but it still applies in those 22 states. Is that right?
That is correct. Yes.
So isn't this a recipe for an even more divided America, where if progressives and liberals bring enough lawsuits, they can at least halt this activity within that part of America, but it leaves the rest of America open game for Trump's lawlessness.
Yeah.
And my question is, but my understanding is now that that case goes back to the district court to actually adjudicate the legal issue, right? And so, assuming that it gets that the district court or whichever court it is sides with the liberals and says, you're right, Trump cannot do this. Then I'm assuming, at what point does someone say, and this has to apply to everyone? Or does it then go back to the Supreme Court and then they can decide the whether it applies, uniformly across the country or not? That's what I don't understand in this whole scenario.
And I want to be careful, David, because I'm both not a lawyer and I was at a wedding much of the day yesterday, and so not I didn't immerse myself in the details of either the case or the analysis of it. I obviously did some research in order to speak with you today.
Sure, sure.
But having said that, my understanding, which I will do further research on, and if I'm making a mistake, get back to you, is that in the case that you're drawing, right? So the circuit court favors the plaintiffs and says
Right.
the Trump administration cannot revoke the birthright citizenship. That decision will apply only to the people who brought the suit, right? Or
Only to the people or only to the states? That's what I believe.
I think in that particular case, because it is 22 states, and it's a class of persons, it might apply to all of those states.
Right.
The figure that sticks in my head is that it won't apply to 26 states. So I don't know exactly why
It's
that is,
48.
and that the injunction doesn't apply to 26 states. Now, please note, right, in this case, given the importance of the issue at stake, given the stakes in our politics, it's almost certainly the case that the circuit court decision will be appealed, the appellate court decision will be appealed, it'll get to the Supreme Court. And when the Supreme Court decides it, that will have national implications. And if the
Right.
Supreme Court says that the circuit and appellate courts were right to say that the 14th Amendment means what it says, then I believe that will be
Right.
national. But the issue here is, right, that it takes a long time and not every case makes its way to the Supreme Court.
Uh,
So does that help?
yeah, that helps a lot. Can I ask one other question before you get
Of
someone
course.
else? And that is, you mentioned that you think that the strategy of supporting the legal defense funds like the ACLU and others that champion the underdogs, that's their traditional role. Uh, why couldn't one argue that it's even more important to give to those groups, and maybe they can bring appeals in the other 46 states and the like, and sort of tie up the courts that way? Uh,
So,
but I understand your logic why uh, we wouldn't want to do that, because the courts are becoming less and less relevant to preserving our rights. But and that says put your money and your time and your efforts somewhere else. But
yeah,
I why couldn't they mount efforts if we all contributed to these funds in those states that are left out from these appeals, like the 22 states that sued on the birthright citizenship?
David, I don't mean you to misunderstand what I said. So I want to be as clear as possible. It may be even more important to contribute to the Southern Poverty Legal Center and the
Right.
ACLU and the Mexican American Legal Defense and Education Fund, the other organizations that are bringing these suits, because these suits are going to become more complex and difficult now, right? They're going to have to either sue in multiple jurisdictions at the same time, or they're going to have to assemble class action suits, which is more difficult to do.
Sure.
So yeah, they'll need more resources, and they're fighting the federal government, right? And so they're fighting against the group that has all of the resources that we provide them with our tax dollars, unfortunately, right? But having said that, what I am saying, I think, is that although it may be all the more necessary to contribute or to support the various legal defense funds, et cetera, that are bringing these suits, it is no longer sufficient. And I'm not
Sure.
sure it ever was, but we shouldn't kid ourselves in thinking that the judiciary is going to be that last bastion of
Yeah.
defense that I think some of us had hoped maybe it would be, and maybe even that it looks like the judiciary was rising to the challenge of trying to restrain the Trump administration. The Supreme Court just hamstrung the capacity
Yeah.
of most judges in the United States to effectively restrain the abuse of power by the president, right?
Thanks.
And so, in those circumstances, we need to change the opinion of the majority of the Supreme Court. And there are multiple ways of doing that. One of them is we obviously hope that Trump won't get any more appointments to the Supreme Court. Certainly not from among the liberal minority, right? I mean, you can think about what a disaster it would be if Sotomayor were to be incapacitated during the next 3.5 years, right? And so there's that path, but that's a long, hard path to elect a Democratic president. I didn't go through the data that I've gone through with you before, but the overrepresentation of the small states in the Senate make it very hard, given that the small states tend to be whiter and more Christian and more conservative, to get right liberal judicial and especially Supreme Court nominees through the Senate. And so that's a long, hard path. Another thing that the protest in the street can do is make it clear to the majority of the Supreme Court, especially the institutionalists like Roberts and maybe Coney Barrett, look, you're losing the people of the United States when you make these decisions. And when you lose the respect and the legitimacy, you lose your authority. You lose your capacity to claim to speak on behalf of the Constitution as opposed to simply speaking on behalf of your particular judicial ideology, which seems to be increasingly partisan. And so to make it clear, yes, I do think that one of the things that is influencing the Supreme Court right now is that there is a relatively popular president who is willing to threaten it and undermine its legitimacy if it doesn't bend to his will. We need countervailing power and pressure. And that's why I think
Yeah.
you don't just think in 2025 writing the checks is going to do it anymore. I think I
Completely agree
saw,
with that. Yeah.
pardon? Okay,
I
let's see.
completely agree with that dual strategy. Yeah.
Good. So Anne had her hand raised a minute or two ago. Wendy, I can't see your button, but I can see you're holding it up. Scat, ask me about scat. What's scat, Wendy? I'm asking. I can't hear you though. Anybody else?
Senior citizens against tyranny.
Senior citizens against
Citizens
tyranny.
against tyranny. Yeah.
Like that. Okay. And then, uh, so Anne, I don't see Anne anymore. Is she still here? Okay, then I'll go to Sarah. I think Iris and Michael also have their hands up. So we got a lot. Today was provocative. Sarah, go ahead.
David, this may be totally oversimplistic, but are you aware of any um, national movement against a sitting government that withholds tax returns?
Um,
I mean, there are quarterly taxes paid by individuals and probably by corporate. I don't know what the corporate, uh,
yeah.
but that seems to be certainly the most direct message to the existing power structure is liquid cash.
Yeah. I'm not sure what to say about that. I know that Gavin Newsom was asked about this in an interview recently, and he said the state of California, because the California, of course, is the largest economy of the states, by far the largest economy, the largest contributor, therefore, to the coffers of the federal government, and that he was exploring measures. I would think that you should be careful doing this as individuals, right? If you're not part of a collective movement. Henry David Thoreau famously did this and ended up in jail for doing it, right? Or was it Ralph Waldo Emerson? Sometimes I
No,
get
but I would
Henry,
think
Emerson, right? Yes,
a collective movement could be built to
right.
the
And
extent that it would be very, very, it would be overwhelming for anyone to take it on and to deal with it individually.
I do like the way you're thinking about it, Sarah. I just have to say, I'm not sure that that's the most direct way for citizens to express their withdrawal of consent from the way in which they're being governed, right?
Right. But
And
excuse me, my concern is that friends who have been very actively participating in protesting, when I've asked what their future plans are, at least three have said that they have given up.
yeah,
And
they can't give up, right? I mean, or if they give up, the other thing I think we should be, beginning to talk about, um, if we are fractured and partitioned as a country, right? If the Supreme Court is increasingly siding with the president, if the Congress is so supine that it's not going to do anything to resist his abuse of power, should we begin to threaten succession, right? And please note that California can leave the United States, can leave the Union, and I'm not saying it should. I think that would be a terrible shame, but boy, would it generate some leverage.
right, I'd love it.
Yeah, yeah. If at least it had that card on the table, it would make a lot of people listen. So yeah, I think we need to get creative. Please note, I mean, I don't know how much you're following the New York City Democratic mayoral primary, but I think there was a very interesting result with a very progressive candidate beating a very well-established candidate who had enough money to absolutely bury, right? Cuomo had 100 times more cash than Mamdani,
Right.
flooded the airwaves with the anti-Mamdani messaging, and Mamdani beat him decisively, right? And so there is, I think, some sign that in the blue quadrants of the United States, which is roughly 50%, at least in terms of population, the politics are moving in uh, a backlash kind of way against the way the nation is moving. And so we should gain, I hope, some courage and some encouragement from those kinds of results. Let's see. Michael, you had your hand up, right? Thank you, Sarah. Interesting question. You're still muted, Michael. You have to hold that space bar or the icon down.
Okay, go
There you
ahead.
go.
Okay, now?
Yes.
Well, I just wanted to say, in terms of not getting discouraged, I think the protests, which have been growing in numbers and intensity, uh, should be an important have an important role to play in certainly arousing greater political uh, uh, adherence to the counterattack on the politics of uh, Trump and his group. So I think those of us who have been relying on our ability to protest and join millions of others doing so should take heart. that if we're going to educate the rest of the population and the rest of the potential voters, we got to keep at it. That's all I'm going to say.
Thank you. And I'm a broken record on this, but I will say that
I know it's not enough. It's not enough. You got to organize in other ways.
exactly. Occasional
Politically,
protests by themselves
not by
don't
themselves.
generate the capacity for resistance we need. If
Yeah.
they're the start of people joining social movements, organizing, regularly meeting when they're not protesting, to strategize, to
And
divide labor,
and
to find
educating,
leaders, then we're in good shape.
educating the passive part of our population.
Yes, absolutely. Good. Iris, you had your hand up a moment ago. You're still muted. Did it pass? I think you're saying not anymore. Yes, okay. Sarah, did you raise your hand again? Go ahead.
Just very quickly to Michael's point, I said exactly that to my friend who who was leaning on me, uh, proving, and she gave me, and I'm sorry, Michael, but I just refer you to to go back to look at if you can find the figures, the the percentage of the national population who demonstrated during the very most recent was startlingly low. I was she was quick to say, but only X number of the total population was out there on the street, which was less than the
Yeah,
first. Uh, it was going down rather than going up. Anyway, I just think
I
it's an
don't think so. It's
interesting
not
figure
going
to
down.
really get a good grasp on.
All right. Yeah, I'm not sure which protests we're talking about. I think the No Kings protests.
Right.
Yes, if you judge it as a percentage, and by the way, there's a group at Harvard Kennedy School that tries to count it. I don't think we've got great data yet on exactly how many people were in the streets 2 Saturdays ago. And obviously, soon in the aftermath of that, or I guess it was 2 Sundays ago, right? Soon in the aftermath of that, and no, it was 2 Saturdays ago. Soon after that, there was a war between Israel and Iran, with the United States joining that war, which we haven't talked enough about. We will talk more about that at some point soon. But the idea that, you know, 5 million, 6 million, 7 million people apparently, we'll have to wait to get the better data, but it appears that it's something along those numbers protested. Yeah, it's a tiny fraction of the American population. It's maybe 2 or 3%, right? But having said that, it's a substantial number of people, and it's broad based in the sense that the people are in every state all over the country as well. So I'm not sure I'm quite willing to agree, Sarah, with what your friend said in pushing back. Yes, it's a small portion, but it's always a small portion. If you think about the large marches that the civil rights movement conducted in the 60s as a portion of the population, it was a tiny fraction of the portion of the population. What matters is the capacity to convey the narrative to those who are not paying attention, right? And I do not know. I'm not sure there's some magic threshold we get to. I think it depends in part not just on the numbers, but the strategy, the way the protest actually conveys the message that you're trying to convey, or the capacity that you're trying to demonstrate. And that is, I think, in part to do with the movement's creativity as well, its strategic chops. And so I'm not willing to say that we're in a moment of passivity or quiescence. I think actually more and more people are rising, but we've got to do more. We've got to do better because, frankly, the power of the federal government now uniformly is directed against us. David, last
Oh,
point
I
for
was just going
today.
to
Go
say,
ahead.
in the recesses of my mind is a figure that some historian put together saying that in general, across the world, it takes 3.5% of the population to rise up against the government in order to get a regime change. But that includes a lot of, small countries and rebellions and the like. So if we had 5 million, that's roughly a little under 2% of the population. So we're not that far out.
We needed 12 million.
Yeah, well,
But 12 million was the number she came up with.
interesting. Yeah, I like I say, I'm not sure there's a magical threshold. At least I'm not willing to suggest there's one. Flossie, give you the last word for today. Go ahead, please.
I know that I was on PBS yesterday, possibly today, talking to some senators concerning the protection of our people, like our journalists.
Mm-hmm.
And actually, I think you can find me talking to Claire McCoskey and two other ladies who are Republicans and who still have some clout in reaching other Republicans. The point is, I was afraid to do it, but I had some encouragement. And I think I'm still around shooting my 2 cents worth.
Please keep doing it, Flossie, and I will try to find that. That's good to know, and I'm certainly happy for what I'm hearing from various people about the level of activity and engagement there. I think this is a moment that demands it from all of us. All right, guys, good being with you today. Not easy times. We'll keep navigating them together. Be well. Take care. See everybody next week. Thank you, guys. Bye-bye.
Thank you.
David.
Pleasure as always. Thank you, guys. Bye-bye.